Welcome everyone. Today is the 9th out of 10 days of the IBIS Prep Bar Exam Bootcamp. And I think of all the courses I do, this is really the most intensive, the most difficult, and the most valuable. And that's why we've kind of dwindled down the amount of people who are here right now to the true soldiers who are here in the 11th hour trying to squeeze a little bit of juice out of the proverbial lemon. And I am the lemon for you today. And if we were talking about like the McNaughton test or the model penal code, then like thinking that it's someone's brain, but actually being a lemon could potentially be a defense, right? So we're gonna talk about all these cool examples today, MBE examples. We're gonna have a really great time. First and foremost, I had my students put things in the chat which were causing them difficulty, and I'll try to pontificate upon them to the best of my ability. So the first one is double hearsay. So what is hearsay? Hearsay is an out-of-court statement proffered into evidence in order to prove the truth of the matter asserted. So when we think of double hearsay, we're thinking of testimony about what Tommy said, right? Well, if Tommy, Johnny is providing testimony about what Tommy said, and if what Tommy said, let's call it a dying declaration, or if what Tommy said was a statement against interest or a party opponent admission, if what Tommy said comes in as an exception or an exemption, then it comes in, right? Johnny is testifying about what Tommy said, and what Tommy said is a hearsay exception, so that could come in. Now, what if Johnny is testifying about Tommy quoting someone else, right? Tommy said that the janitor said XYZ. Well, now, even if Tommy's statement was an excited utterance, excitedly uttering what the janitor said, we got to look at the janitor statement on the inside. So that's why I realized what it was this morning when I was doing my daily morning music therapy session. And it was a Limp Bizkit song. If y'all remember who that is, Fred Durst. And I always say this, and I know my students don't understand what I'm talking about, but that he said, she said, right? He said, she said, that's what it's all about. And it's that concept right there. So double hearsay is like if someone is saying what someone else said, and the person who's providing the testimony is testifying to what someone else said that someone else said. So it really is that inner outer layer of hearsay where both the inside and the outside layer have to come in. The example that you see tested on the NCB question is the one about the staircase. And it's like, right, the inner layer comes in because it provides notice, and that's an exception, but the outer layer still doesn't come in because it's someone saying that someone had notice of it instead of just someone having notice of it. So that's the concept of double hearsay. It can be really hard to pick. And Renato, one of my students, helped explain that the answer was no because it's hearsay. It didn't say no because it's double hearsay, meaning that like, yeah, hearsay is double hearsay. I'm not saying they're synonymous, but if something constitutes double hearsay because the outer inner layer cannot come in, then that effectively means the statement is hearsay, because in order for it to not be hearsay, both the inner and outer layer would each have to be exceptions or exemptions or some reason for their own admission. So that's a little bit about double hearsay. All right, the next question was about recording statutes. So recording statutes, you have to read the statute first. If I see a question that has a recording statute, I jump right to the language of the statute and I determine, is it a race jurisdiction? Is it a notice jurisdiction, or is it a race notice jurisdiction? And there's certain indicators that'll allow you to determine that. If it's a race jurisdiction, it will say first to record. First to record, it's a race jurisdiction. If it's a notice jurisdiction, it will say without notice. So if it says whoever records first prevails, or if it says whoever takes without notice prevails, whatever it may be, it'll be a notice or race jurisdiction. Now, if it says first to record without notice, that makes it a race notice jurisdiction. So what are the implications of each? Race jurisdiction, you're just looking at who was the first person to record. Whoever recorded first, they're going to prevail. If it's a notice jurisdiction, you're looking to see who is the last bona fide purchaser. Who is the person who took for value in good faith without notice? And just look down the line, and the last bona fide purchaser will prevail. And once they are a bona fide purchaser, they cut off any interest that anyone before may have had. And now they're the one with interest. Anyone who takes after them, even if that person takes with notice or takes as a donee, can take shelter in the status of the upstream bona fide purchaser. So a bona fide purchaser is someone who takes for value in good faith without notice. And what notice means is actual notice, like they knew someone had an interest in the property. Constructive notice, which could be record notice, meaning it was recorded, so they should have known because it was recorded, or what can be tested as inquiry notice. Even though they had no idea of it, even though it wasn't recorded, someone was occupying the property, someone was making use of the property that would have put a reasonable person on notice. So that's going to be inquiry notice. If that person has any of those things, notice, or they didn't pay for it, they're a donee, or bad faith is involved, they're not a bona fide purchaser and they won't prevail. But if they are, then the last one in the fact pattern, the last bona fide purchaser who satisfies all the conditions will prevail. Now, if it's a race notice jurisdiction, they need to be the bona fide purchaser who's the first to record. So you're looking to see who's the bona fide purchasers here and then who's going to be the one of those bona fide purchasers who first records. That's going to be the race notice jurisdiction. Another little wrench they could throw at you or caveat is some statutes will identify whether a judgment creditor operates as a lien on the property. If it does, then they'll pretty much act as a bona fide purchaser or act as someone who has rights under the recording statute. If they don't, then they won't be able to take priority. Certain things like purchase money mortgages usually take priority. I'll get into mortgages, in a subsequent issue, but yeah, that's the concept of recording statutes. Identify which type of statute is it? Is it race first to record? Is it notice that we're going to protect the bona fide purchaser? Or is it race notice where we're going to protect the bona fide purchaser who records? And if you can just kind of understand those concepts and look through them, I actually think they end up being some of the easier questions. Now, that's after 7 years of doing this, right? Okay, relation back doctrine. Relation back doctrine is when you can relate back to amend claims. I think the thing that they test the most that's tricky about that is the reason for relation back under the Federal Rules of Civil Procedure is to amend when there's been a misidentification. You meant to sue Tommy, but you sued Tammy, right? It was like an identical twin and you sued the wrong person potentially. Not when it's strategic or not when you could have originally brought the claim, right? That's not why we're going to relate back. We're only going to relate back to fix something, more cosmetic, more of a mistake than a strategic decision or something that they could have brought. And if it does relate back, then yeah, that will, kind of make it so that it doesn't violate the statute of limitations or whatever it may be, because it will literally relate back. So that's what you're thinking about for the relation back doctrine. And whether something relates back or not is federal, it's going to be procedural under the Erie doctrine, right? That's a procedural concept, relation back, if we're looking at diversity case under Erie. Just so a kind of good segue, what is Erie? Erie means that in a diversity case, we will apply federal procedural law and substantive law of the state where the federal court is sitting. In fact, under Claxon, we'll apply the choice of law of that Erie state when it comes to substantive issues. Some things that are procedural are like choice of venue, the order of the witnesses, whether or not the experts need to submit to an examination, relation back, like I just talked about. Those are things that may be procedural. Substantive would be like elements of the claim, like, what's necessary to prove murder or statute of limitations or damages or privileges. These are things that would be substantive under Erie. Remember, Erie doctrine only applies in diversity cases. If it's in federal court because of a federal question, you apply federal procedural and substantive law. Erie is only going to apply in diversity cases. Claim preclusion and issue preclusion, someone asked about. Claim preclusion means that the claim is barred or the claim has merged, meaning it cannot be brought again. It's the same party in the same configuration. A versus B, A prevails, right? Well, A can't bring the claim again and win twice. A versus B and A loses. A can't bring the claim again and then try to prevail. Things that give rise to claim preclusion would be adjudication on the merits, right? A final decision would be 2 voluntary dismissals, 1 involuntary dismissal, a dismissal with prejudice. These are certain things that will give rise to claim preclusion. Remember, the same parties, same configuration, or their privies, same party or their privies. The most common type of privy on the MBE is an employee of an employer. So the company prevails, and now the driver, the truck driver of the company tries to bring suit. He'll be most likely barred, or the claim will have merged under the concept of claim preclusion. Offensive versus defensive. Offensive is if you're using proactively, like a sword. Defensive, you're using it defensively, like a shield. And merging or barred. If the plaintiff prevails in the original proceeding, the claim is merged. If the defendant prevails in the original proceeding, the claim is now barred. Those are some, little issues about claim preclusion. Issue preclusion is more narrow. It's not the actual entire claim. It's just one of the issues. It has to have been actually litigated. So look for a special ruling, not a general ruling. Look for an actual decision, adjudication, not a voluntary dismissal or something like that. Issue preclusion is usually between the same parties, which we call mutual issue preclusion, but some jurisdictions allow non-mutual issue preclusion, which would allow another party to assert issue preclusion. Issue preclusion applies to the parties and their privies, and the most common type of privy that will signify issue preclusion will be a subsequent landowner. So if A goes against B, A wins, saying, oh, there's an easement, that's like an issue, and then A sells the land to C, C can assert issue preclusion as a privy. So for claim preclusion, we see employer-employee. For issue preclusion, we see subsequent landowner when it comes to privy. Issue preclusion, claim preclusion are very tough. When it talks about will that under Erie, right? Will that be procedural or substantive? Very difficult question. The answer is it is procedural, right? Preclusion is procedural, but they will incorporate the preclusive effect of the first court where the ruling was made. So if it's filed in state court and that state, doesn't allow non-mutual issue preclusion, or that state has, 2 voluntary dismissals or adjudication on the merits, even if it's a federal diversity case, they will apply the preclusive effect of the first court where the case was filed, even though that is federal. It's just federal incorporation of the judicial system, let's say. Okay. Can we go over specific intent crimes? Sure. I think there's a good mnemonic that's even a student can fake a laugh for ridiculous bar facts. E is for embezzlement. A is for assault. Recognize that assault is only specific intent in the majority of jurisdictions. It can be general intent in the minority of jurisdictions. What that means is, in the majority of jurisdictions, assault is attempted battery, so it can actually merge into battery, and it's specific intent, the intent to commit battery. That's the majority decision. The minority decision, the minority, view is that it's like at civil law, where assault is just placing someone in reasonable apprehension of imminent harm or offensive touching. But as a specific intent crime, it stands for the A in at least my mnemonic. Well, my interpretation of the mnemonic. So embezzlement, assault, solicitation, conspiracy, first-degree murder, arson, larceny, fraud. Even a student can fake a laugh for robbery, burglary, and forgery. Embezzlement, even. Assault, A. Solicitation, student, S. C, conspiracy. F, first-degree murder. A, arson. L, laugh, larceny. F, the other one, fraud. R, robbery. B, burglary, bar, and then F, forgery, right? Those are pretty solid ones, like the theft crimes, the fraud crimes, and first-degree murder, and the inchoate crimes. I think that's a good way of specific intent crimes, where you need to show that they had this specific intent. Attempt is the most heavily tested one. If I, want to shoot this lady and she's dead and her corpse is on the floor, but I don't know she's dead, and I stand over her dead body and I blast away trying to shoot her, do I have the specific intent for attempted murder? Even though she's already dead? But I don't know she's dead. I'm trying to kill her. I think she's alive and well, but she's already dead. I do, right? I attempted to kill her, right? Attempt is like, if you tried to do it, you'll do it. Now, will I be found guilty of murder if I blasted away at a corpse? No, right? She was already dead. But attempted murder, yes. If I didn't know she was dead and I wanted to kill her, that's attempted murder. So think about it like that. So yeah, it's gonna be the specific intent crimes where they actually have to have that specific intent to constitute the mens rea behind the crime. Okay, so the new trial standards, so some important standards. So summary judgment at civil law means there's no genuine dispute of material fact, taking all facts in the light most favorable to the non-moving party, we will find that there's no genuine dispute of material fact. That would be summary judgment, after discovery. For a JMOL, judgment as a matter of law, or a new JMOL, the standard is that no reasonable juror could find for the non-moving party. There's substantial evidence to support a verdict for the non-moving part, or for the moving party, I'd say, but no reasonable juror could find is the standard for JMOL or renewed JMOL. The standard for a new trial, the most commonly tested one, is the verdict is against the manifest weight of the evidence. It's against the weight of the evidence is the most commonly tested standard for a new trial. So the amendments for review, sure, amendments are easy, right? I can recite them in my sleep. Like First Amendment is right. First Amendment is the freedom of speech, freedom of religion, freedom of press, freedom of petition, freedom of assembly, right? Freedom of press, freedom of petition, freedom of religion, freedom of speech, and freedom of assembly. Freedom of speech, content-based, content-neutral, strict scrutiny versus heightened intermediate scrutiny, time, place, and manner. Unprotected speech is like hate speech, words likely to incite imminent lawless activity, defamation, false or misleading commercial speech, obscenity. These are types of speech that are not protected in the First Amendment. Religion is free exercise and free establishment, and then petition, assembly, and the press are pretty self-explanatory. Second Amendment is, right to bear arms. Third Amendment, your right not to have to shelter a soldier during wartime. Heavily no, I'm just kidding. Never tested. Fourth Amendment is right against unreasonable search and seizures. They'll need probable cause to issue a warrant. And we think of the exclusionary rule through the poisonous tree doctrine, the exceptions to the need for a warrant, the spaces mnemonic, search instant to arrest, plain view doctrine, automobile exception, consent, exigent circumstances or hot pursuit, and then stop and frisk, right? Spaces, search instant to arrest, plain view doctrine, automobile exception, consent, exigent circumstances or hot pursuit, and stop and frisk. Fifth Amendment, 5 things tested on the Fifth Amendment are due process, which is notice and hearing. The takings clause, which means that in order for there to be a governmental taking or for them to exercise eminent domain or condemnation, there must be just compensation. The Fifth Amendment includes the famous Dave Chappelle skit, I plead the fifth, right? The right against self-incrimination, 1, 2, 3, 4, 5, right? That's the right against self-incrimination, civil and criminal, and even in a grand jury, you retain the right to the Fifth Amendment to right against self-incrimination. The Fifth Amendment is right against double jeopardy. You can't be charged with life or limb for the same crime twice. Think of that as the criminal equivalent to claim preclusion, right? The prosecution can't bring the same charge against a person twice. There's some times where maybe there's like the person later dies and now they can bring manslaughter when it was first burglary. But then there's other times where it's like if they've been acquitted of the underlying felony, then they can't later be convicted of felony murder, right? A lot of nuances to this, but in general, the concept is double jeopardy really is the idea that they can't be charged with the same crime twice. And then, of course, the Miranda rights. When you're in custody, a custodial interrogation, when a reasonable person would not feel free to leave, they have the right to remain silent. They have the right to an attorney, and if they can't afford one, will be provided for them. And anything they say can and will be held against them. And that's the Fifth Amendment right to counsel. If you're just getting pulled over, for speeding, that's not custody, right? They don't have to read you Miranda rights. Can they ask the passenger to get out of the car? Yes, they can, right? When they're doing a stop, they can do a search of the vehicle. Technically, they cannot search the trunk without probable cause, and technically, they shouldn't be able to search a locked glove compartment without probable cause. Now, if the glove compartment is unlocked, the argument that I'm familiar with, but some MBE questions can be very tricky, is that if it's unlocked, technically they can have reasonable suspicion that there could be a weapon in there, and then they could search it because it's unlocked, it's within their, wingspan, so it's a little bit less clear there. If a police officer is going to search a student at a public school, they need probable cause. If the principal is going to search a student at a public school, they need reasonable suspicion. Now, what they like to test is the police officer using the principal to do a search as an agent. They would need probable cause there, the principal, because the principal is acting on behalf of the police officer. So, if you're growing marijuana plants in your backyard and your neighbor could see it, so can the cops, right? That's the concept. There's the open fields doctrine where, like, if you are growing marijuana in the shed in your farm and it's, not your curtilage, it's pretty far away, it's probably something that can be searched without probable cause. These are some considerations of the, Fourth Amendment, and then Fifth Amendment we talked about, due process, takings clause, Miranda rights, right against self-incrimination, and right against double jeopardy. Sixth Amendment is your right to counsel after adversarial proceedings have begun, right to a speedy trial, confrontation clause, right? Consider what's testimonial and the exception for the ongoing emergency. The Seventh Amendment is your right to a jury trial for civil issues where the relief is legal in nature, so monetary, or it was actionable with a jury trial at common law, like writs of ejectment, for instance, where they tell you in the fact pattern that they received a jury trial at common law, but usually it's for legal claims. The jury trial always comes before, even if the legal relief claim is in a counterclaim, they'll still do the jury trial before they do the non-jury equitable claim. If the legal claims and equitable claims are tied together, they all get a jury trial. If it's a class action, but the underlying claim is legal in nature, then yes, they'll get a jury trial. Eighth Amendment is against cruel and unusual punishment. 10th Amendment is state sovereignty, police power, anti-commandeering clause, federalism, the idea that the states can operate themselves, but they can't run afoul of the federal government. The 11th Amendment is sovereign immunity, the idea that individuals can't sue the state, but they can sue state actors in their individual capacity or the state for injunctive relief. And the state cannot sue the federal government. However, the federal government can sue the state. There's the 13th Amendment, which prohibited slavery and applies to private action, which bans discrimination based on race. And the 14th Amendment, which is equal protection, which implicates strict scrutiny, intermediate scrutiny, rational basis, suspect classes. It applies to the states. The Article 5 or the Section 5 of the 14th Amendment applies due process. Due process through the concept of reverse incorporation applies to the states, but think of Fifth Amendment for due process, 14th Amendment for equal protection. Privileges and immunities clause from the 14th or Article 4. These are going to be related to discrimination against out-of-staters or discriminating against the right to travel, let's say. You should definitely know your fundamental rights, like things that are subject to strict scrutiny, race, alienage, and national origin. Remember, alienage, though sometimes will be rational basis, is if it's related to the functioning of government, like serving on a jury or being a police officer or something of that nature. And discrimination towards like women or men triggers intermediate scrutiny, but only if it's targeted, not if it just has an effect of burdening them in some manner. 15th Amendment, can't discriminate on race for the right to vote, and 16th Amendment related to taxing and spending. And then I think 19th Amendment, you can't discriminate, or it gave women the right to vote. So thank God for these amendments, right? They've come a long way, and you should know them pretty well. Mortgages, that was mine. So mortgages, what's a mortgage? A mortgage is a loan secured by real property, and the lender, the mortgagee, can foreclose on the property if the borrower, the mortgagor, fails to pay back the loan, right? It's the property acts as collateral. And the concept that's tested a lot is expressly assuming versus taking a mortgage subject to. If the new party expressly assumes a mortgage, they become personally liable, and the original party is secondarily liable. if a new party takes a mortgage subject to, they are secondarily liable and the original party is primarily liable. Unless we have a true novation, the original party will still be somewhat liable, but it's a question of whether they'll be personally liable or liable secondarily as a surety. If the surety makes the payments, then the law of suretyship allows reimbursement from the primarily liable party.
Andrew, can
Purchase
you
money mortgage.
go over the situation where somebody puts up property as collateral for the mortgage, but they didn't sign the promissory note?
Yeah, can you guys just put comments in the chat?
Sorry.
Yeah, I'll address that at the end maybe. But yeah, the concept of mortgages and expressly assume and subject to is that if you expressly assume, you become primarily liable. If you take subject to, then you're going to become secondarily liable. A concept that's heavily tested is purchase money mortgage, which means that if you are a mortgagee and you loan the mortgagor money and the mortgagor uses that money to buy the property itself, then they automatically have super priority as a lender. So look for the purchase money mortgage lender and consider that they may have super priority in the property. Yeah, mortgages are pretty heavily tested. Okay, when prosecutors can have the burden of proof shifted. So the burden of proof in a criminal case is that it needs to be beyond reasonable doubt, and the burden is on the prosecution to prove the elements. Like, if they were dead or not, like mandatory presumptions on essential elements are not allowable. So you have to actually show them the body. You can't say they were murdered if we don't show them the body. That's something that needs to be proven beyond a reasonable doubt. There's some things that are known as affirmative defenses, which the burden can actually be placed on the defendant, and the burden can be lowered to clear and convincing, or let's say preponderance of the evidence. These could be like insanity defense is a classic one. And remember, there's no constitutional right to an insanity defense. So they could actually eliminate the insanity defense, and that's totally constitutionally allowable. They could also place the insanity defense on the burden of the defendant instead of the prosecution to prove whether or not they were insane or not. And that's totally allowable. It could be self-defense, right? Self-defense could be put on the defendant to prove, and the standard could be lower. There's certain things like consent. If it's rape, that's not really an affirmative defense because that's really an element of the crime, right? If they consented, then it really wasn't rape. Or alibi. Alibi is not an affirmative defense because if they had an alibi, then they actually didn't do the crime itself. So I think that's kind of a way of thinking about when the burden can shift. If it's actually something that's an element of the crime, it has to be on the prosecution beyond a reasonable doubt. If it's some sort of affirmative defense, like insanity defense is the most common, then the burden can be shifted, lowered, and that's how that applies. So sure. Contracts question that you were talking about. I mean, the best example I can answer this question, and I'm sorry for I'm just trying to keep it foundational here. Some of your questions I know are a little bit pointed. But what I can best answer actually for this question is if there's an agreement to pay back money, right? And they say, you know what, it's due, it was due, but you pay me back in 3 months at 3% interest and XYZ. Well, in that situation, there is new consideration. Why? Because there's additional interest. The 6 months that are going to pass over those 6 months, 6 months, 3% interest, 18%, compounding, they're going to pay more. If it's just, hey, the money was owed and now I'll pay the money in 3 months, but it's the exact same amount of money without interest, then that would not be new consideration. Another thing to recognize is the prior existing duty rule, right? The prior existing duty rule means that if you are already obligated to do something, then it's not going to constitute new consideration. But a common exception to that is the agreement to pay off a debt, right? So if A owed B $1,000 and then A and B make an agreement to pay back 500 on this date, even though A already owed B 1,000 and now A owing B 500 is not new consideration. We don't need new consideration to enforce that new debt because an agreement to pay back an existing debt is a common exception to the prior consideration rule. All right, covenants versus easements. So a real covenant is different than equitable servitude because a real covenant is writing, but an easement is a possessory interest in land. So a covenant is more of a restriction, like you have to pay parked here, you have to have the, doors painted blue, you have to have this tree, trimmed to this length, whatever it may be. That's a covenant that could run with the land if there's notice, intent, touches and concerns the land, and there's privity, things of that nature. Whereas an easement is a right of use. So it's not like a rule or restriction like a covenant is. It's a right of use, like a right to cross it or something. There's affirmative and negative easements. Affirmative easement is like a right of access or right of use. A negative easement is like air rights, view rights, riparian rights, water rights, things like that. There's express versus implied. Express is written or ideally recorded, and implied is oral or implied by some mechanism. There's easement appurtenant, easement engross. Easement appurtenant runs with the land, it's tied to the land, there's a dominant and serving estate. Easement engross is personal in nature and is just tied to like the utility company or something like that. There's easement by prescription and prescriptive easement, adverse, open, continuous, adverse, notorious, hostile for the statutory period. And then there's easement by necessity, which means that a land is so locked in, it's hemmed in that there's no access to a public road. So those are all different forms of easements. Yeah, so types of easements, yeah, I kind of just went over them. Express, implied, affirmative, negative, easement engross, easement appurtenant, easement by prescription, and easement by necessity. Okay, see, Ariana, for consent, if consent is an element, but it's also for an offense, then they're allowing them to shift even if it's still an element for rape, for example. Again, pretty pointed question. I'd have to see the exact actual question if it's an element of the crime or if it's an affirmative offense. Consent can be kind of tough. Can you discuss foreclosure situations when a person grants a mortgage to a lender, but a person did not sign the promissory note? Again, it's kind of a pointed question. I would have to look at the actual question and see what happens there. All right, amazing. So that pretty much brings me to the end of that little lecture. My hope was just to hit you with some fundamental points. If there's at this point in the game, if there's little things that are so nuanced and detailed that they're driving you crazy, forget about it. Go back to the fundamental important things and be like, do I know what the standards are for JMOL, renew JMOL, a new trial? Okay, got it. Do I know what the differences between negligence per se, res ipsa loquitur, and some other Latin term that we may see? Just try to focus on the fundamental things because there's 200 questions out of a possible 100,000. You don't know exactly what's going to be tested, but you can be confident that the main important things are going to be tested. So the last thing I'll leave people on is the concept of judicial notice. Look to see if it's civil or criminal. If it's civil and it's something that they must take judicial notice of, then they also must accept it as conclusive. So if they must take judicial notice in a civil case, they must accept it as conclusive. In a criminal case, if they must accept or they must take judicial notice, right? It's something they must take judicial notice of, but it's a criminal case, they may, but are not required to accept it as conclusive. So I've taken the MBE 4 different times, and 3 of the 4 times this question came up. So something I could tell you, you're very likely to see. And these are the things that you should focus on, things you're likely to see. And this is civil judicial notice. If they must take judicial notice, they must accept it as conclusive. In a criminal case, if they must take judicial notice, they may, but are not required to accept it as conclusive. Really appreciate everyone for hanging out with me. I hope this was valuable. Tomorrow is the last day of the boot camp. It's going to be a lot like this, but it won't be recorded. But it'll be a lot of me just talking. It'll be more interactive, right? Me, maybe doing some research on my own and working with the class. But I'm going to probably put breakout rooms of UBE, Florida, MBE. And if you're taking 2 exams, you can bounce between them. I'll bounce between the 3. And then otherwise, I'll have the questionnaires and I'll have someone being the ringleader, maybe Heather or Alex or, students who have really shown a ability to lead, and I'll have them doing the blank questionnaires where it'll just be like, Heather would be like, Ashley, what are the different types of easements? And then, as Ashley would know, she would say express, implied, appurtenant, engross, by prescription, by necessity, and affirmative or negative. And she would get gold stars, and we would move forward to the very next question. So that's what tomorrow's going to be a lot of, unless you want to take another practice test. And honestly, if it was me, I'd be 50-50. I kind of see how I'm feeling in the morning. If I'm feeling like a lot of you are feeling today, kind of worn down, then I would just join the breakout rooms and do the questionnaires and the, the walkthrough. If I was feeling good, I'm like, you know what? I want to do a little bit better than yesterday and take another full-length practice test. You're more than welcome to do that. Everything that's submitted will be graded, including the essays. So it's been an absolute pleasure. As y'all know, I have a student coming up in 10 minutes, so I'm going to stop this recording.